a groundbreaking new immigration law has officially passed today, and it's already sending shockwaves through the immigrant community across the United States and around the world. If you hold a green card or know someone who does, what I'm about to share could directly affect your immigration status, your international travel plans, and your entire path to United States citizenship. This isn't speculation about what might happen in the future. This isn't a legislative proposal still working through Congress. This law has passed, it's now official federal law, and the sweeping changes take effect sooner than most people realize. Stay with me for the next several minutes because understanding this new law in detail could literally be the difference between protecting your permanent resident status and facing serious legal complications that could jeopardize everything you've worked years to achieve. The stakes are genuinely high, and millions of green card holders have no idea these changes are coming. Welcome back to my channel, your source for verified, no-nonsense immigration updates that cut through the confusion and give you the facts you absolutely need to know to protect your status and your future in America. Before we dive into the specific provisions of this new law, let me establish some critical context that will help you understand why this matters so profoundly. A green card, officially called a lawful permanent resident card, grants you the legal right to live and work permanently in the United States. It's genuinely one of the most valuable immigration statuses in the entire world, opening doors to opportunities that billions of people can only dream about. But here's what many green card holders don't fully realize, or perhaps have forgotten since they received their cards. Your green card comes with ongoing legal responsibilities and obligations, and those responsibilities can change when new laws are passed by Congress or when federal agencies update their regulations. United States immigration law doesn't stay frozen in time like a photograph. Congress, federal agencies like US Citizenship and Immigration Services and the Department of Homeland Security, and presidential executive orders regularly update immigration policies and enforcement priorities. Some changes are relatively minor and technical. Others, like what we're discussing today, are significant enough to require immediate attention and action from millions of green card holders across the country. So, why is this new law that just passed different from routine policy adjustments? 3 fundamental reasons. First, it changes compliance requirements that have been standard operating procedure for decades. Second, it introduces entirely new verification procedures that will affect international travel and re-entry into the United States. Third, it impacts pending naturalization applications in ways that immigration attorneys didn't anticipate. The broader 2026 immigration policy environment has been intensely focused on modernization, enforcement, and what policymakers are calling status integrity. This law is a major part of the larger strategic shift. Before we break down the 4 major areas this law changes and the practical steps you must take immediately, please subscribe to this channel and turn on notification alerts so you never miss critical immigration updates. Hit that like button to help this information reach more people who need it. Now, let's get into what actually changed. The law passed today is officially titled the Lawful Permanent Residence Integrity and Verification Act of 2026. It's dense, it's highly technical, and it's filled with legal language, but I'm going to break it down into 4 major areas that affect you directly. The first key change involves new eligibility and status verification rules. Under the new law, green card holders must now verify their permanent resident status through a federal database every 24 months. This is completely new and unprecedented. Previously, you would update your address with USCIS when you moved using Form AR11, and that was generally the extent of your ongoing obligations unless you were traveling internationally or applying for citizenship. Now, you'll receive an official notification, likely through both postal mail and email, requiring you to confirm basic information, including your current residential address, your employment status, and confirmation that you haven't abandoned your permanent residency. This verification process takes approximately 15 minutes to complete online, but failure to complete it within 60 days of receiving notification can result in status review proceedings being initiated against you. Here's a realistic example to make this concrete. Let's say Maria has held her green card since 2022. Under the old rules, as long as she continued living in the United States and didn't violate any laws, she was perfectly fine. Under this new law, when she receives her 24-month verification notice in 2027, she must log into the new USCIS online portal, confirm all her details are accurate, and submit the verification. It's not optional. It's not a suggestion. It's a legal requirement. The second key change involves travel and re-entry considerations, and this is where green card holders are expressing the most serious concern and anxiety. The new law explicitly states that any green card holder who spends more than 180 days outside the United States in any single 12-month period will be subject to enhanced screening procedures upon re-entry. This doesn't automatically mean you'll be denied entry into the United States, but you will need to affirmatively demonstrate that you haven't abandoned your US residency. What does enhanced screening actually mean in practical terms? It means mandatory secondary inspection at the port of entry, additional detailed questions about your ties to the United States, such as employment, property ownership, and family connections, and potentially significantly delayed processing times that could keep you waiting for hours. Previously, the informal rule understood by immigration attorneys was that absences of more than 6 months raised questions, and absences over 1 year created serious risk of abandonment findings. This new law codifies much stricter scrutiny starting right at the 6-month mark. Example: Raj is a software engineer with a green card. His multinational company sends him to their India office for 7 months for a special project. Under the old system, he might face some questions from Customs and Border Protection, but would likely be admitted without major issues. Under the new law, he's now required to carry extensive documentation, proving his intent to maintain United States residency, lease agreements, employment contracts, tax returns, evidence of family ties. He may also need to file a special form before traveling if he knows in advance he'll be outside the United States for more than 180 days. The third major change introduces annual reporting requirements for green card holders in specific categories: those who hold green cards through employment-based sponsorship, those who obtained status through investment programs, specifically EB-5, those with conditional permanent resident status, typically from marriage-based applications. If you fall into any of these categories, you'll now need to file a brief annual report confirming your employment status, business activity, or marital status for marriage-based conditional residence cases. This report is separate from your federal tax returns and separate from the 24-month verification I discussed earlier. The stated purpose, according to the law's congressional sponsors, is to prevent fraud and ensure that green cards obtained through specific pathways are being used as originally intended. The fourth key change is something that caught many experienced immigration attorneys completely off guard. The new law extends the continuous residence review period for naturalization applications. Previously, USCIS examined the 5 years immediately before you applied for citizenship, or 3 years for spouses of United States citizens. The new law allows USCIS to review your entire period of permanent residence when evaluating whether you've maintained continuous residence and physical presence requirements. What this means in practice: if you've held your green card for 8 years and you're now applying for citizenship, USCIS can look back at all 8 years for any extended absences or compliance issues, not just the most recent 5 years. This doesn't change the 5-year or 3-year requirement itself, but it dramatically increases scrutiny for applicants with complicated travel histories or significant time spent outside the United States. So, why are people calling this law shocking? Let me be absolutely clear about something important. This law does not automatically revoke anyone's green card. It does not create brand new deportation categories. It does not ban international travel. But it does create substantial new obligations and potential consequences that many green card holders weren't prepared for or aware were coming. The shock and concern come from 3 main factors. First, the lack of widespread advanced public notice. While this bill was working its way through Congress, it didn't receive major media coverage until this week. Many green card holders are learning about these fundamental changes only now that the law has actually passed. Second, the retroactive review provision for naturalization applicants. People who traveled extensively years ago thinking they were in full compliance may now face difficult questions during their naturalization interviews about trips they took 5, 6, or 7 years ago. Third, the new administrative burden. The 24-month verification system, the annual reports for certain categories, the enhanced documentation requirements for international travel. These all create new responsibilities that require time, attention, and careful organization. Let's get extremely practical. Here's your step-by-step guide for what to do right now. First, stay informed through official channels only. Bookmark and monitor USCIS.gov, EDHS.gov, and travelday.state.gov. Do not rely solely on social media forums or unofficial sources where misinformation spreads rapidly. Second, review your current status and history thoroughly. Pull out your green card and verify your current address on file with USCIS. Create a detailed travel log documenting all international trips with dates and purposes. Third, gather and organize documentation proving your US ties. This includes lease agreements, tax returns, bank statements, employment verification, and family connection evidence. Fourth, monitor for your verification notice and respond promptly within the 60-day window when it arrives. Fifth, consider professional legal guidance if you have extensive international travel history, compliance concerns, or pending naturalization applications. Let me address consequences because understanding the stakes helps you take this seriously without panicking. If you miss the 24-month verification, you'll receive multiple notices before any serious action is taken. USCIS has stated they'll make several attempts to contact you. However, systematic non-compliance over months or years creates serious problems. If you fail to document extended travel properly, you may face extensive secondary screening or even have your residence questioned by an immigration judge. Let's bring this all together. Today, a new United States immigration law passed that fundamentally changes how green card holders interact with the immigration system. The core changes include mandatory verification every 24 months, enhanced scrutiny for travel exceeding 180 days, new reporting requirements for specific categories, and extended review periods for naturalization applications. These aren't minor administrative tweaks. These are structural changes that require you to be more organized, more documented, and more aware of your ongoing obligations as a permanent resident. If you've been maintaining genuine ties to the United States, if you live here, work here, pay taxes here, and consider this your home, you're going to navigate this successfully. But you absolutely need to take these administrative requirements seriously. If this video helped you understand this new law, please hit that like button right now. Subscribe to this channel and turn on notifications because I'll be following this story as USCIS releases implementation details and as we learn how this law affects real people. Share this video with anyone you know who holds a green card because the biggest risk right now is ignorance. Drop a comment below with your questions and I'll address the most common concerns in follow-up videos. Your green card represents opportunity, security, and your future in the United States. Protecting it doesn't require perfection. It requires awareness, organization, and commitment to meeting your obligations. Stay informed, stay compliant, and stay protected. I'll see you in the next update.